Good afternoon. I want to thank everybody for logging and calling into the webinar today. We have a special guest with us. At Advanta IRA, we're huge believers in education and taking a lot of time to tell you not only about self-directed IRAs and what's possible for investments, investing in real estate, notes, mortgages, you name it, but also bringing in professionals in certain areas of industries that are kind of tangentially related to what we do at Advanta. So we have an attorney on with us today. We'll be bringing him on in a few minutes as we get the webinar started to talk specifically about landlord and tenant law. One of the big, investments we see at Advanta IRA is investments into rental real estate and people wanting to buy and sell properties with their IRA accounts, their old 401ks. So today we're going to be able to address some questions on what do you do once you have a tenant. And obviously that's a very central and very key part of an investment into rental real estate. So we're happy to have Conrad Grant here with us today to talk with that. But before we get in to what Conrad has to share with us, I wanted to let you know of our next upcoming webinar will be next Thursday from noon to 1. And if you're somebody who is listening to recording of this, you might be able to find the recording on our YouTube channel as well. All of our recordings are on YouTube. If you're somebody who's listening live to the presentation today, don't want to forget to let you know, if you have questions for myself or Conrad, you can type those into the chat box on your screen, and we'll make sure to get those answered during the webinar today. But our next webinar coming up is next Thursday from noon to 1. Be more general how to structure a real estate deal and buying and selling property and other assets, real estate assets within a self-directed IRA. So today we're going to talk about some things kind of after you've already done that process. You've already bought the property, things you need to know with landlord and tenant. But next Thursday, we'll talk about kind of the first step in the process almost of what's involved with buying a piece of real estate within a self-directed IRA, what the rules are, what you need to know, et cetera. So please make sure to join us next Thursday at noon Eastern Time. A little bit about myself. My name is Scott Maurer. I'm the Director of Business Development for Advanta IRA. I've been with the company for over 10 years, and my role now, I started out doing a lot of the transactions and helping people through buying and selling real estate, going through that closing process. But more of my time now is spent educating individuals on what's possible with a self-directed IRA, what you can do, things you can't do, trying to forge those relationships, and really, again, let more people know about what self-direction is and what is possible with those types of accounts. Now, a quick disclaimer, we add this at every webinar and seminars that we do. The thing we do at Advanta, we do administration and record keeping. We do not give financial advice, and we don't give any legal or tax advice as well. So when it gets to making a decision on an investment or what you're going to do with your IRA account, if it has a legal or tax component to it that you're unsure of, we can certainly point you to attorneys and CPAs, individuals to help you make those determinations. Now, we do talk about some legal and tax issues when we do our seminars. We just can't help you make a determination in that regard. And especially when it gets into making an investment, we don't give you advice. It's up to you to find the property, decide what it is that you want to buy, how much you want to pay for it, and certainly in context of what we're talking about today, what tenants you're going to put in there, what kind of rents are you going to charge, et cetera. So we've been around since 2004. And the only thing, again, that we do is administration and record keeping. We don't sell products. We simply hold those investments that our clients want to make. It's real estate, private placements, notes, precious metals, a lot of different things you can invest in with an IRA. Our job is to simply hold it because most brokerage firms, Charles Schwab's, the Fidelities, Morgan Stanley's of the world, aren't willing to hold these types of assets. IRS rules certainly allow for it, but you have to have a custodian like Advanta to hold those assets. And what sets us apart in our industry is our customer service. We are dedicated to providing a superior service for all of our clients, regardless of account balance or number of assets you have in your account. Every client gets an account manager, one person that works with them regarding all aspects of their retirement account. Now, just a quick, really brief overview of real estate and an IRA for those of you who may be listening and a little unfamiliar with this aspect of investing. What types of accounts could you invest into real estate? Any type of IRA, a traditional, a Roth account. If you have a SEP or a simple IRA, those can certainly be used as well. We have 401ks for individuals who own their own business, And certainly if you have any former employer's plan, like an old 401k, an old 403b if you work for the school board, or a thrift savings plan if you work for the federal government, those plans can all be self-directed. It's a matter of opening up an account with us, transferring or rolling over those monies, and then telling us what assets that you want to invest in. And when it comes to the types of assets, again, rental properties, which is what we're going to focus a little bit more on today with our guest, is rental properties have tenants, and you have to know the laws in dealing with certain tenants. But rental properties, it can be a fix and flip that you're looking to do with real estate, tax liens, mortgage loans, private stock, private placements, precious metals. The list really does go on and on. The IRS has a very few restrictions on what you can or can't do with a self-directed IRA. So what I would encourage you to do, again, we're not going to get into too much detail today on that, it would be to attend the webinar next Thursday to find out more about what you can do, or go on our YouTube channel to see other webinars on other topics that we've covered. Just to go through a very quick example, what does it look like for someone to buy a piece of property? In this example, simply Paul has money in a traditional IRA account, wants to buy rental properties, wants to find a foreclosure that he can find for sale. He can get it for 80 grand, and he's got 100 grand in his IRA, so it's an all-cash deal, very simple transaction. And he thinks he can net, about $1,000 a month or so after he gets the property fixed up and gets it rented. So the role that Advanta plays in this transaction is that we're going to assist Paul from the closing from the contract all the way through the closing to make sure all the paperwork and documents get titled correctly. So Paul is going to open up and fund his account, contact us to get our paperwork, get the document, get the account open, get the funds transferred. He's going to find the property, going to make the offer to purchase, and our job then is to make sure that the offer is in the name of his IRA, and then once the offer is accepted, work with the closing agent, work with the attorney that's handling the closing to make sure that all of the closing documents are titled correctly and properly in the name of the IRA account. Paul is going to have to approve all the documents for us. We're not going to really know necessarily what the settlement statement should show as far as buyers and sellers costs, so he's going to need to review that for us, give us his approval, at which point we will wire funds out of his IRA. Though we may have transferred that money in from another IRA account. We'll then send that cash to the closing agent and complete the purchase. And then going forward, all the expenses related to that asset, the maintenance, taxes, repairs, insurance, all must be paid out of the IRA, and all the income must go back into the IRA. So our job at Advanta is to manage that process and be the record keeper for your IRA account. You have your tenants send the rent checks directly to us, deposit them to your account. You send us the invoices, the expenses for your account. We get checks cut out of the account and keep track of, obviously, the income coming in, the expenses going out, doing any other IRS reporting that might be needed. So obviously, if you're buying a rental property, and we mentioned a few slides ago that the key thing was to have, obviously, you're going to have monthly cash flow. To have monthly cash flow, you're going to need to have a tenant. And if you're going to have a tenant and they're paying rent back to your IRA account, you're going to want to need to make sure that you're following the rules and some of the laws that go along with being a landlord with your IRA account. So we're very happy to have with us today Conrad Grant with the law firm of Kelly and Grant down in Boca Raton. Conrad is joining us today. He's going to share a lot of just good general information, but he does practice in the state of Florida. He'll let you know a little bit more about that. So there might be a couple times in today's webinar where the laws that he's speaking of are specific to the state of Florida, so you'd be encouraged, obviously, to talk to an attorney in your own state. But hopefully Conrad's going to share a lot of other just good general information with us. So Conrad, are you there?
Yes, I am.
Great. Conrad, I want to thank you again for coming. Before you get started, I just want to remind everybody, if you're listening live, type your questions for Conrad or myself into the chat box on your screen, and we will make sure that we get those answered as we go along. So Conrad, without further ado, I'll hand it over to you.
Great. Thank you. Well, as you guys know, I'm licensed to practice in the state of Florida, so I can't practice law anywhere else, but this information, you can glean some general information out of this, and then you can look for the law specific to your state. But the good news is that a lot of you are investors in Florida, and if you're not, this is where all the investors are coming. So chances are at some point If you live in one of the border states like Georgia, you will be getting investment properties in Florida at some point because the market down here is very great. We have a lot of landlords and investors that we represent in our firm, and this is a very popular presentation, and I think you will learn a lot from this. Now, let me start off by telling you who we are. Law firm of Kelly & Grant. It's myself, Conrad Grant, and I have a partner, Jaron Kelly, and we started this firm. We represent hundreds of landlords all across the state of Florida, and we also handle title and closing in addition to other real estate matters. So let's get started. All right, so here's the first thing we're going to talk about. This is what we're going to talk about today: squatters. These are people who move into your property without permission. You've got to know how to deal with these people. We're going to talk about tenancies, which is the main topic of this presentation. Tenancies, how to properly terminate them, the eviction process, joint stipulations, and then we'll talk about security deposits and improving your return on investment. And as I said, a lot of this is going to be Florida specific, but you will glean a lot of information out of this that applies nationwide. So what is an unlawful detainer? All right, an unlawful detainer is used for squatters and unwanted guests. There are three important things to note: that you have a legal right to possession of the property, you've asked people to leave, and they've refused to vacate. So an example of this, usually we get a landlord or a homeowner, not a landlord, a homeowner who invites someone to stay and then that person refuses to leave. A lot of times investors buy property and there's someone in it who was never a tenant, and that person has to be evicted under unlawful detainer. So sometimes it could be the former owner, a family member of the former owner, and you will need the unlawful detainer method. At least in Florida, you will need that method, and I'm assuming it will be similar in some other states because these people are squatters. It never applies to tenants or people who have paid rent. So that's a different analysis. When someone says to me, this is a tenant, or they used to pay rent somewhere to someone, then they're not unlawfully detained in the property. We will then serve them a notice to vacate, and then we'll file suit against them. In Florida, we have what's called summary procedure, which is it's a very expedited process. And for example, if someone files a suit, it's usually a 20-day summons. Under Florida law, with evictions, you're looking at 5 days. 5-day summons, the tenant has 5 days to respond. So as an investor, that's a good thing to know, that you can quickly evict tenants. Moving on from that, we're going to talk about properly terminating tenancies as it applies to Florida. So the first thing you have to do is post a 3-day notice. Now, I've seen it in other states. We have clients in other states, and they come to me with a notice, that doesn't satisfy Florida requirements. But generally, there's some sort of notice that you will need to file. So in Florida here, we do a 3-day notice. Here are some of the rules for that. I'll run through them very quickly. You can't use a P.O. box as a landlord's address, or you have to add 5 extra days. You have to accept the rent, because think about it. You're demanding rent. You're given a 3-day notice to pay or to leave. So if they pay you, you have to take the money. So if you have some kind of automatic payment system, you cannot lock out tenants during that 3-day period. They need to be able to deposit their money or pay during that 3-day period. After the 3-day period, you don't have to accept rent. You can't give an early notice. If the lease gives you until the 5th, don't post it before that. Don't include late charges. Don't include utilities. The only thing you can add to that 3-day notice for non-payment is the rent only. And you cannot include the day that the notice is posted. You have to avoid mailing, or you'll have to add 5 days. It's just the rules here. If it's a Section 8, Section 8 is a great investment. The rules aren't much different. The only thing you have to do is notify HUD or whoever the housing manager is that you're taking these steps, and give them copies of everything that you have. This is, I usually present this as a little joke for people, where it's like, this is a 3-day notice. Is this a 3-day notice? Uh, it doesn't meet statutory requirement, all right? I don't know if it'll work anywhere else in the country, but I know it does not work here in Florida. Here is what a proper 3-day notice should look like. You'll have the date in the upper right, and you have the tenant's information, and then this is plucked directly from the statute. You see it's a 3-day notice for non-payment of rent, and we've made this foolproof. So this is what you want to do. The first thing, as soon as your tenant is late, don't wait around, don't listen to excuses. That's how you start losing money. And this goes for anywhere in the country you are. This is your investment. They're going to fall behind. As soon as the tenant is late, your policy should be to post a 3-day notice immediately demanding the rent. You have to fill in these blank lines. They're statutorily required, and if you don't, your eviction case can get dismissed by the court. And that is how you handle 3-day notices. Another thing you need to do before you post that 3-day notice is to consult your ledger. I can't tell you how many times I've gotten a 3-day notice that's defective for many reasons, but the main reason being that the rent amount is wrong. If the rent amount is wrong, the court can dismiss your case. But it's also good business practice. I hate going to court when the judge says to the landlord, do you have a ledger? And they say, no, I just keep it in my head, or I use a receipt book. That's not a good way to protect your investment. It's not a good way of doing business. So you should track everything. And then when it's time to serve a 3-day notice, you know that your 3-day notice is going to be accurate. Florida law states you can only demand the actual rent, and the only exception to this is if the lease deems everything else as additional rent. For example, you can say there's a $35 NSF charge. This NSF charge shall be deemed additional rent. $40 charge for posting a notice. This is deemed additional rent. So what we've done, and these are little tricks that investors can make can use to make a return on their investment, is you use these little tricks to ensure that you don't lose money. If you have to send someone to the property to post a notice and it costs you money, you should be able to pass that on. If there's an NSF charge, you should be able to pass that on to the tenant, but you need to deem these things additional rent. Examples: late fees, return checks, the utilities, administrative fees, repairs. You can say, if tenant, you're responsible for all repairs under $100, and if I have to make the repair and charge you for it, it's going to be deemed additional rent. So those you can then put on your 3-day notice, but otherwise you can't. Incorrect amount in your 3-day notice, it's one of the most disputed or litigated areas in Florida law, and your case can get dismissed based on incorrect rent. So keep that in mind. It's very important. So here are some practical considerations prior to serving your 3-day notice. Example 1, monthly rent, $1,600. Tenant is behind 5 months, and the ledger shows the following entries: $1,600 January, February, March, April, May, and then I see $160 in late fees for May. So the first thing I do as an attorney, and what you should do as an investor or a landlord, is you should consult your lease. If you inherited this lease from someone when you bought the property, you need to consult it. You need to make sure that that May late fee is deemed additional rent, and if it's not, you cannot ask for it. You can only ask for the $8,000. All right? Otherwise, you're going to waste a lot of time in court, and you're going to lose attorney's fees and court costs if you lose that lawsuit. Here's another example. It's a Section 8 tenant. Monthly rent is $1,483. The ledger shows the following: $48 for water and sewer, and May rent is $606.53. The amount in the ledger. The landlord serves a 3-day notice for the amount. If it's challenged by the defendant, what do we need to prove in court? We need to prove that the water bill is additional rent, and if it's not, then the court can dismiss your case. And I've had this litigated so many times that I train my clients, and if my clients come to me with a defective 3-day notice, I tell them you may lose some time, but it's best to do this notice over so you don't lose time and money. All right? Now, let's talk about terminating month-to-month tenancies. A month-to-month tenancy is one. It's formed by either a lease expiring and the landlord then accepting rent, or there's never been a lease. Some guy shows up and he asks if he can live in your property and pay rent, and you say yes, and he starts paying you rent. That's a month-to-month tenancy. In some other states, it's called an at-will tenancy. In Florida, you have to give a 15-day notice to terminate month-to-month tenancies. Some landlords, some investors like month-to-month tenancies because if you don't like a tenant or it's not working out, you can just easily tell the tenant, I want you to leave in 15 days. Of course, you have to give it in writing versus you have a bad tenant and you have to wait an entire year. So some landlords do that. It's your strategy, personal strategy, investment strategy if you want to do something like that. The only defense a tenant will have is retaliatory eviction. So you have to make sure your evictions in general are not retaliatory. This means tenant reported you to code. You then say, I'm going to terminate your lease or your rental agreement or your oral agreement, whatever it is, just because you reported me to code. That's a very good defense, so you have to make sure it's not retaliatory. You can use your 15-day notice to terminate a tenancy for any reason, though. As long as it's not, as I said, it's retaliatory or something discriminatory. Even if a tenant pays on time, you can terminate their tenancy. And it's actually good if you're planning to sell the property at some point. You can terminate the tenancy if maybe the buyer wants it without a tenant. So sometimes it's good to put a tenant on month to month if you know you're planning to sell that property. So here's an example for terminating month-to-month tenancies. There's never been a lease. Rent is due on August 1st. Tenant pays the rent but is chronically late and does not get along with other residents. The landlord can serve termination notice no later than August 16th. And I'm going to show you how that's done. A lot of people think that all they have to do is serve a 15-day notice and count 15 days and that's the end of it. So today being November 4th, they assume they could just post a 15-day notice and the tenant should be out by the 20th, but that's not how it works. That would mean you're terminating in the middle of the term. So here's what I'm talking about. This is August 2016. The 16th of August is the last day to serve that 15-day notice. And the reason why is because rent is due on the first of the month. So the way you have to think about it is like this. The notice needs to expire the day before rent is due. If rent is due on the 1st, the notice needs to expire either the 30th or the 31st, except for February, of course. All right, so the last day to serve your notice, this is how you count your 15 days. Day 1 is the 17th of August. And when you count all the way to the 31st, that's your 15th day. And then on September 1st, that would be the day that rent would be due. You shouldn't collect rent at that point if your intent is to evict the tenant, or you'll have to do this over. All right? Now, here's another
Conrad, can I ask you a quick question, just kind of looking back at that? So is it good in practice then probably not wait till the 16th or the 15th, or if you know you're going to have them out, maybe serve that notice, earlier on in the month? Would that cause any issue?
You can serve it early, and that's an excellent question. A lot of times, this presentation we give is pretty interactive, so I'm actually glad you chimed in with a question here. It's a good idea to give it earlier, but not too early. Because if you serve this 15-day notice on the 1st before rent is collected, or even at the end of July before rent is collected, because you're being nice, you're trying to give the tenant extra time, the tenant's not going to pay you. That's just how it works. Human nature. You're kicking me out. Why should I pay you? I'm not paying you anything. So I would say if rent is due on the 1st, the tenant pays you the rent on the 2nd, you can serve them that 15-day notice on the 3rd. All right, you can serve it earlier. You just cannot serve it later. So that's a pretty good, very good question.
Okay, well, thanks. And yeah, and again, anyone who's listening live, type your questions into the chat box on the screen if you're there, and we'll get Conrad some more questions. So thanks a lot. Keep going.
Thank you. Here's a second example. Lease expired a month ago. The parties never renewed, but landlord accepted rent. Under the lease, rent was due on the 15th day of every month. The notice must be served on July 30th and will expire on August 14th. So this is another scenario where rent is due on the 15th instead of the 1st. This is how you would count your days. You'd calculate your days. This is the last day to serve a notice. If you look, it's July 30th. Day 1 would start on the 31st. Now, of course, you can serve it earlier. You can always serve earlier. You can give 2 months if you want. I've seen landlords do that. They give a lot of time, but you should never put that in your lease. Just as a sidetrack, I've seen people put that in their lease. That they'll say 30-day notice or 60-day notice if we're going to terminate your month-to-month tenancy. If in the event it becomes month-to-month, and that is way too much time. You can choose to give more than the statute requires, but the statute only requires 30 days. So 15 days, my apologies, 15 days. So the 30th is the last day to serve, and then as you see, the notice will expire on the 14th because the new rental period starts on the 15th. So always terminate the day before the rent is due and count backwards to make sure you've gotten your 15 days. All right, and you can never count the day that the notice is posted. And that's an easy way to terminate month-to-month tenancies. You just have to calculate it correctly. It's a great way to handle your investments and keep tenants in check, so that you're assured that you can quickly put paying tenants into the property once a tenant becomes a nuisance. The next method, so I've listed 2 grounds for terminating tenancies, which is non-payment of rent, terminating month to month, and then this is the big one. This is terminating for breach of lease. In Florida, you have to give the tenants an opportunity to cure. In 99.99% of all occasions, you have to give the tenants an opportunity to cure. So a breach is curable when there are unwanted guests, unauthorized pets, you name it, it's curable. It's not curable if it's a criminal activity. Tenant assaults someone, murders someone, rapes someone. You can't have the tenant cure that. You have to terminate at that point, but otherwise you're going to ask them to cure. So you would serve a 7-day notice stating, on such a date I observed that you had an unauthorized guest residing in bedroom 2, and you have 7 days to cure this. According to the lease, you're only allowed to have 2 people living in the apartment, and you have 3. Or I noticed that you have 2 dogs when you're supposed to only have 1. You give them 7 days to cure that, and if they don't cure it, you can file a lawsuit against them. The only problem with this is the burden of proof is on you. When we do a 3-day notice for non-payment of rent, the burden is on the tenant to prove that they paid the rent. When you file an eviction based on a notice to cure, the burden is on the landlord to prove that the tenant violated the lease, which would mean you need to have pictures, you need to have police reports, you need to have affidavits, you need to line up your witnesses. So if you can avoid doing it this way, then you'll be in better shape. You won't have to spend a lot of money on lawyers fighting an eviction and having a trial on whether or not the tenant violated the terms of the lease. You just need to be very sure. You also need to avoid self-help in Florida. So if you think a tenant should have put water in their name, you discover a month later that it's still in the landlord's name, At that point, you cannot just disconnect it. You can't allow it to be disconnected. That would be an indirect disconnection of utilities. You would actually need to give the tenant a notice to cure. All right. There are people who've done that in the past. They'll say, well, it's in my name, I'm just going to let it lapse. But that is indirect disconnection of utilities, and at that point, if you go to court, you would owe the tenant 3 months of rent. That's just the law in Florida, 3 months of rent. If you're an investor, that's a lot of money you're losing. You're losing 3 months of rent, and when you calculate your property taxes and your insurance and so on, you might not even make any money for that year. So you need to do this one right. Okay? Here's an example of a 7-day notice to cure. This is the way we typically do it. I won't read through the entire thing, but I'll read the first paragraph. In this one, the landlord was clearly just reaching. In the first paragraph, you have not changed your air conditioning filter, which is your responsibility under paragraph 10 of your lease agreement. I threw that in there. To me, that alone isn't enough, but if you really want to get rid of a tenant, then throw everything into it. But here's the key thing. You stated what the problem was, the air conditioning filter, and you stated what part of the lease or the statute they're violating, paragraph 10 of your lease. And then at the bottom, demand is hereby given to you. We tell them what they need to do. They need to cure this issue. So I'll read number 3, for example. You have made unauthorized alterations without first obtaining the landlord's written consent. Paragraph 17 of the lease clearly states that you cannot alter the premises without permission of the landlord. You have altered the premises by changing the locks without receiving permission of the landlord. Please provide copies of the keys to the landlord. So we've stated what the problem is. We've stated that there's paragraph 17 of the lease that states that you need to provide keys to the landlord or get permission, and then we tell the tenant what they need to do. All right, and if they don't do it and it's important enough to the landlord, then the landlord can file a lawsuit and have the tenant evicted. So here are some examples for terminating tenancies. Tenant changed the locks. Tenant refused to allow landlord to enter the premises. The landlord needs to inspect the premises to make necessary repairs, but the tenant refuses to cooperate. Landlord must serve a notice to cure, and if the tenant fails to cure, the landlord can start the eviction. But you also need the proof. Remember, burden of proof is on the landlord at that point. Another example, tenant has frequent loud guests for late night parties. Landlord has never witnessed this but has heard the complaints from several tenants. Landlord should serve a notice to cure. But the problem here again is, how are you going to prove this? As an attorney, I always think, how are you going to prove this? You don't want to spend a lot of money in court just to lose because you cannot prove this. I had a recent case where the landlord served a 7-day notice, and it said for noise, prostitution, criminal activities. It was pretty vague. Then when we went to court, the only thing that the landlord had was police reports, but the police report did not specify the tenant's name. The police report just said, we've been called to this property several times over the last month because of these issues. So the judge actually dismissed the case. This is a case I took over that a landlord had already filed with their 7-day notice, which wasn't very specific. The judge dismissed the case and said it's not specific enough. There's no information in the police report which states that it's this tenant who committed the crimes or who was loitering or was involved in prostitution. So you can see the problem there. This is, I need to nail this, repeat this, and so you can nail this down, that the burden of proof is on you. Example 3, tenant punched another tenant, threatened to kill him with a knife. There's a police report. Landlord may serve notice of termination also. All right, any questions on this so far?
Yeah, Conrad, I had a question. Would, kind of going back to example 2, loud guests and other issues, are written complaints from neighbors, maybe who go on the property records and figure out who the owner of the property is, and they sent you a written complaint? Is that good evidence, not good evidence, or is that hearsay?
It's hearsay. Yeah, it is hearsay. It might be persuasive to some judges, and I'll tell you why. Because in county court, a lot of judges they have a heavy caseload. They try to be as informal and quick as possible. So some judges will just say, "Yes, look at all these letters. I think there's a problem. You need to leave." Some judges will do that. But if the judges are following the rules of evidence and so on, then, and you have to assume that all judges will do that, just follow the rules of evidence, that would be hearsay information unless you can bring in that neighbor to testify and corroborate the information in the letter. So that's not good enough evidence. Good question.
Okay, and I had one other one going back. It was a couple slides ago. Talked about the getting the water and the power in the name of the tenant. Is that something you can require? Maybe it's getting a little outside the presentation, but is that something you can require in the lease, that they provide proof that they have changed the water over to their name before they can even inhabit?
Yes, and you should always do that. And in fact, you should never hand over the keys until they change it over to their name. And what you can do is say in the lease ahead of time, you can say you're required to put this in your name on the 1st. Let's say they're moving in on the 1st. On the 1st, it will be disconnected, and you already reached out to FPL in Florida, that's Florida Power and Light, and you've told them that they should disconnect that. But the better practice is to not let them move in until they take the lease down to the local utilities, whatever they need to do, and get it placed in their name. All right, and a good way is to put in the lease that it will be disconnected on a certain date and time, and let them initialize that. All right, that's the best way to do it. Any other questions on that?
No, I don't. But again, if you're listening live, you have the opportunity now to get some of your questions answered. So please get those typed into the box.
All right. Moving on. So here's the process. This is the process as it works in Florida. Depending on the county, Florida has 67 counties, and although the rules should be the same, it isn't. You're looking at about 4 weeks. So from the point of view of an investor, Florida is a great state to be in for evictions. If you think about the northeastern states, New York City, for example, where it could take 6 months and you're losing money the entire time, in Florida, it's about 4 weeks from start to finish to wrap a case up. Our bigger counties, like Miami, which has a lot of people in Broward County, they may take a little longer. If the case is contested by the tenant says, I don't owe the money, or I didn't do this, or I didn't do that, you can add 2 weeks because the judge is going to set it for a hearing, and you're going to have to go into the hearing and prove your case and so on. So you're looking at about 6 weeks, but in general, we can wrap up cases in smaller counties in less than a week. You move that tenant out, you get a new tenant in. So here are the steps in the uncontested eviction. You have to deliver your notice first. File the eviction in county court after the notice expires. A process server will serve the tenant with a 5-day summons. Remember, I mentioned this before. It's only a 5-day summons, not 20. So that's great. Motion for default. If the tenant does not file an answer, we submit a final judgment to the judge. The judge takes about 10 days on average to enter a final judgment. When the judge issues the final judgment, he issues an order that the clerk should disperse a writ of possession to the sheriff. The sheriff then goes to the property, posts a 24-hour notice. Of course, it's not exactly 24 hours. It's usually a couple of days later. The sheriff will call the landlord or the property manager and say, listen, I'm going to head to the property at 10 a.m. on Monday, and you need to be there. And at that point, the sheriff will remove everyone from the property, and you have possession of your property again. So from start to finish, you're looking at about 4 to 5 weeks, 4 to 6 weeks in Florida. So what if the tenant files an answer? And this is where you kind of start losing time and money, and this is why you need to do everything properly to begin with. Because if you miscalculate your rent, the tenant's going to file an answer, and the tenant's going to say, I don't think I owe that amount. The judge is then going to set it for a hearing, so you've wasted time. What a judge can do is order rent into the registry. Another great thing about Florida law is if a tenant files an answer, the judge can order the tenant to deposit the rent in the court registry. So the tenant files an answer and the tenant says, yeah, I know I was late, but I lost my job, whatever it is, the judge can say, all right, you need to deposit the disputed rent into the court registry. The rent is $1,800. It's $900 for October, $900 for November. Deposit that in the court registry, and if you don't, you're getting evicted. So you're protected. The judge can also order mediation. So if a tenant puts the money into the registry, the judge can say, all right, guys, go talk about it. I'm ordering you to mediation. Go settle this. Apparently the tenant wants to stay. Tenant put the money in the registry. So landlord, work it out. The judge can also order a hearing to determine rent. This is where the tenant says the amount isn't correct. Florida law says that the judge can either order an amount in the registry or order a hearing to determine how much a tenant should put into the court registry. Or that some judges would just go straight to a final hearing. They just say, I just want to get this done in one shot. They'll set it for a hearing and you prove your case right there and then, and it either goes your way or it doesn't. Depending on the judge, sometimes we can move to strike the tenant's answer, or we have to force the issue and set it for trial. Because some judges, when a tenant files an answer, some judges will just let the case sit there and they will not do anything. All right? So I'm looking here. Let me look. I see a few questions here. Do I have a sample lease? I do, and you can get that information from me. Or Scott will contact me and you can get that information, or you can call my firm. Another one, does the 5-day summons begin when the summons is served or when it's issued? It begins when it's served. It's either served by posting or it's served by hand delivery to the tenant. In Georgia and North Carolina, is it proper to add a confession of judgment? Can't answer that. I'd be practicing law in Georgia and North Carolina without a license. But you can look that up or call one of your local attorneys and ask them about that. But I wouldn't know how to answer that question. All right, moving on. During the eviction process, so this is a great way to protect your investment. It's joint stipulations and settlement agreements. It's a really powerful tool, and it can be used to accomplish the following. You can give the tenant a second chance, save the cost of filing a new eviction, recoup the money that the landlord paid for attorney's fees and court costs. You can get past due rent. You can get the tenant to agree to move out, or you can modify the terms of the lease. You can correct mistakes. It's a great tool, and here's how this works. So you file an eviction against the tenant. The tenant says, I do have some money. I want to work something out. I'm going to be getting my tax return. I have a job right now, and I can get caught up. So rather than you do an eviction where you lose your court costs, you lose your attorney's fees, and you lose time, you work it out with the tenant. You come up with a plan. The tenant will pay you the past due rent. They'll pay you back your court costs and attorney's fees, and if they can't pay it immediately, you can put them on a plan saying you're going to pay on the 15th, you're going to pay $200 off the court costs. On the 15th of December, you're going to pay another $200. However you want to structure it, you can do that, because here's a good thing. If the tenant defaults on any of those terms of the stipulation, you don't need to file a new eviction. We reopen that old case and we say to the judge, the tenant has defaulted on the terms. Here's an affidavit from the landlord stating that he didn't get the money that was due on the 15th, and the judge will order a final judgment. And it could be 4 months down the road, the tenant defaults on the terms of the stip. I'll call it a stip. The tenant defaults, and you can get an eviction without filing a new one. So it's a great way to save money, great way to give the tenant a second chance, put some money in your pocket, not having to rehab the property and re-rent it to someone. And a lot of times the tenants will pay because they know you're serious, and they know that if they make a misstep, they're going to get evicted. So a joint stipulation is an excellent thing to use.
And Conrad,
Yeah.
the joint stipulation, I'm assuming that's something that the average person is going to need to get an attorney to help them with, correct? That's not something you want to try to do on your own.
No, and you know what? I'll tell you. As an attorney, I can sit here and tell you that, yeah, you should let an attorney draft it. If you can, if you're an LLC or a corporation and so on, Florida law says you got to be represented by attorneys, all that. But let's say you're a landlord and you're doing all this yourself. You just want to do this yourself. You file the eviction yourself, and then the tenant says, I want to work something out. Write up a common sense agreement. Now, the case has to be filed already, because now you're going to use the judge's power to enforce this. So the case is filed, you draft up a stipulation, anything you want to say. You sit down, you say, all right, listen, guy, I'm going to help you out. Yeah, all right, you owe me $1,800. I want $900 now, and by Monday I want the other $900, and you owe me some miscellaneous charges and my court costs. I know you can't pay it now, but I'm going to split it in 3 payments. And you write it out clearly, and both of you sign it, and you file that with the judge, with the court, saying that you settled this case, and it's enforceable. The court has jurisdiction to enforce that. So to answer your question specifically, it is better if an attorney can draft this. But if you're just, you have 1, 2, 3 properties and you're trying to save some money and have them perform well, do these yourself after you file a lawsuit. Settle with the tenant. All right? Does that help?
It does. We had a couple other quick questions come up.
Yes.
One is, are these joint stipulations and settlements, they're done after the initial filing of an eviction, correct?
Yes, and that's correct, and that's a good question, because if you do it before, all you're doing is modifying the terms of the lease. You still have to file an eviction. It doesn't change anything. So you draft up something saying that the tenant's behind and they're going to pay you back over time. If that fails, you have to file a new eviction because there's no one to enforce it. While when you file that lawsuit, you're backed by the power of that judge. The judge is going to ratify that agreement and say, this is now a court order. These 2 parties have decided to settle. I agree with the terms of their settlement, and I'm ratifying it, and this is now a court order. I have power to enforce the terms. If you do it before, there's no judge, there's no case. It cannot be enforced except by filing an eviction. Hope that makes sense.
It does, and another question, there was somebody asked about a confession of judgment in Georgia and North Carolina, but they want to know if that's legal in Florida.
Yeah, and I think I had addressed that I couldn't answer that.
Right, but they're
because
asking
I don't know.
Is there a similar instrument in Florida law?
No.
Okay.
No, there's no such thing. Let me read that question. See if I can find a way around to answer it properly. Is it proper to add a confession of judgment in the lease where a landlord need only to provide proof of the amount owing to obtain a judgment against a tenant and have it executed on their property? No. In Florida, the only thing Chapter 83 gives you is the power to get possession of the premises. You can sue them on account 2 for the money, but the court still you have to win the case, and then the judge awards the damages. You have to have a hearing on damages, and then you will have a final judgment for damages, which you can then record with the county, and then you can start, doing liens and trying to garnish wages and so on. But no, there's no mechanism like the one you just described in that question. There's no mechanism that's comparable to Florida. All right?
Yeah, and we had one other question said the question, I guess, in response to what you said. So if you have an LLC that owns the property, do they need to use an attorney for an eviction and a joint stipulation situation, like to represent them, or do they just need to have a third party? Or could the manager of the LLC do it?
All right. So Florida allows a property manager or a landlord, if this happens to be an LLC or whatever, it allows them to file an eviction. But the law also says that as soon as the tenant files an answer and it becomes contested, you need to get an attorney. All right? So if the tenant files an answer and it's contested, then at that point, the law would step in and say you, as the LLC or corporation, would need to get an attorney. Now, as a practical matter, if that tenant comes into the office and wants to sign off on something and try to settle it, I think the court would accept it. You just cannot go represent the LLC or corporation in court when the judge orders a hearing. You can't file motions and say, please strike the tenant's answer because they're wrong, because you're not a lawyer. And the property manager is not a lawyer, the office manager or whoever, they're not lawyers. But I believe if you filed that eviction and the tenant came in and said, I have all the money, I want to work something out, you can draft up an agreement, and I think the court would accept it, all right, without an attorney. Did that answer your question?
Yeah, I mean, it was somebody posed that, but I think that was a good answer. So yeah, let's keep moving.
Yep, I see that question. All right. Example 2, monthly rent is $1,000. Landlords file suit for $2,000 past due rent. Tenant files an answer alleging wrongful eviction, failure to maintain the premises. Tenant attaches code violations. Tenant said he would be willing to vacate the premises in 2 weeks. The judge set the case for a hearing in 10 days. What would the landlord do in this situation? In this case, where you really just want your property back and the tenant has pictures showing that the landlord has violated code and they haven't maintained the property, that's going to be litigated, and the judge might not like that. But here's the good news. The tenant said, listen, I'll move out in 10 days. So now you don't have to go to court. If you file this yourself as a corporation or an LLC, you don't have to go get a lawyer because the tenant said they're going to move out. So the tenant, you draft an agreement that says, I will vacate in 10 days, and you can keep my deposit or whatever terms you want to put in there. You file it with the court, and you're done. I think that's a better scenario than going to court in 10 days and wasting more money and your time when you could be doing something else, such as looking for properties to invest in or managing your other properties. So that's another good thing about joint stipulations. It can end the litigation early, give the tenant a chance to move out. All right.
And Conrad, I had a question. I've heard a lot of people discuss this before too. It's kind of either a way around the eviction process or shortening it. Mm-hmm. What are your thoughts on kind of like cash for keys situation, where offering the tenant money to leave in exchange for the keys? Are there some risks involved in doing that?
No, it's actually a good idea. If you bought the property and there's someone in there and you pay them to go, that's fine. You're not doing anything illegal. You're giving them a choice. Here's some money. We terminate this agreement early. Now, if it's your tenant, and you want to do something like that, you want them to leave early. Let's say you're trying to sell the property. The other investor says, I don't want it with a tenant in it. So whatever the reason is, but you need to get rid of the tenant, and the tenant still has an active lease. Yes, you can pay them, but I would also suggest that you write up a mutual termination of the agreement. And you don't really need an attorney to do something like that. Both parties are just agreeing that we agree that the lease is terminated and we're going to move out at the end of the month, and that's it. It's signed. Once they move, you give them the money, but there's nothing illegal about it. I'd just rather you have it in writing. All right, but it's a good short way to prevent litigation and get your property back. Good question. All right. Moving on to, we're going to talk about security deposits, and these are definitely Florida-specific rules. All right. While you can glean information for other states, this one is just Florida-specific. I haven't seen anything similar in other states. But returning the deposit, you have to do this within 15 days. So tenant moves out, the property is in good shape, and you're going to return the deposit. The law says you have to do it in 15 days. Okay? If you're going to keep the deposit, you need to give a notice of intent to retain that deposit, and you have 30 days to do that. You have to follow certain rules. It has to be in writing. You have to give the 30 days. You do it within 30 days, and you have to send it by certified mail. All right? You say, tenant, when you moved out, you left holes in the wall, the door was broken, whatever you want to list, and then you list how much money it's going to take you to make those repairs. So you say your deposit was only $1,500, but it's going to cost me $2,000. You always want to list more if you can, or you list the full amount, and therefore I'm making a claim on your deposit. That's your only obligation. If you don't know where the tenant moved to, you send it to the last known address, which is obviously your address, because the law assumes that the tenant has forwarded his or her mail, so it should get to them. That's all you need to do. Obvious question, people say, what if the tenant never signs for it or they never pick it up? Well, you have no control over that. All you can do is what the law requires of you. All right. The tenant then has 15 days to object in writing. So the tenant can object and say, I don't agree with that. I left the property in immaculate condition. And then the next question landlords ask, all right, I got a letter from the tenant saying they object. What do I do? At that point, the ball is in the tenant's court. The tenant can sue you, but it's up to them to sue you. The landlord can say, you know what, this isn't worth it. The deposit was only $800. I'm not going to take the risk of a lawsuit, so I'm just going to give them their money back. You can do that. Sometimes you can give them a half. You can say, listen, I know that I can go to court and win on this, but you know what, I'm going to give you half of this back. And you send them a check for half, you avoid litigation. It's just a way of avoiding litigation and wasting money because, yes, you'll spend money on your attorney's fees and you're entitled to it when you win, but if the tenant can't even pay their rent, you think they're going to pay attorney's fees and court costs? You're just throwing good money after bad. So sometimes it's best if the amount is small enough to just give them their deposit back and have them go away. All right? But otherwise, if you do everything right, you can keep it. You can keep the deposit. If you did not send it within 30 days, you automatically lose. That's just the law. There are attorneys who will sit and wait for that day 31, and then they'll say, hey, Larry, landlord, you failed to return the deposit within 30 days. If you don't return it, we're going to sue you, and we will win. And you have to return it because that's what the law says. You missed that time. You missed the 30 days that you're required to send it back in. All right? Any questions on this?
Yeah, Conrad, somebody did ask what is considered wear and tear after a year. And I don't know if that's a question that you can really answer, but I think that's what they're asking in regards to security deposit.
Yeah, wear and tear, that's a tricky one. As one judge said, he said, you know wear and tear when you see it. You know, the property has been lived in. Paint, if it's a family of 4 with kids, you know, the paint is going to be, you know, it's going to need repainting. The carpet might be worn down a little bit, as long as it's not intentional damage. So wear and tear is, you know it when you see it. Now, if there are holes in the wall, the cabinet doors are broken off, the oven door is broken off, you know, the knobs for all the doors are broken, that's not normal wear and tear. That's intentional or misuse of property, all right? But wear and tear is just, it's kind of a common sense call. The property has been lived in, and you know, these are the things that are just going to happen. You know, and the longer time frame that the tenant has lived in the property, the more wear and tear you would expect. So that should, I hope that answered that question.
Okay, yeah, there's one other one that came up just to quickly get to before we move on to wrap this up here in a few minutes. But if you were giving back a partial deposit, so, you know, $500 security deposit, you're sending them back a check for, say, $250. If you write, someone's wondering if you write full payment on the check, if that person takes it and deposits it, is that acknowledgement of, you know, and waiver of any rights they would have had to the rest of the deposit?
It's evidence. It's evidence. What I would do is I would send a letter with it, stating, you know, I'm returning $500 if you accept this. You know, so it's evidence, and it's going to prevent the tenant from trying to sue you, because they know if they cash that check, then it's over with. But as a lawyer, I can tell you that all it is persuasive evidence, but it's not binding on the tenant. The tenant can still bring that suit for the rest of it. Will they do that? 99% of the time, no. So it's good to write that on it and send that letter off, because most tenants, they're lay people. They don't know the law. They need that money, and they're going to believe that memo that says if they cash it, then they've waived their right to sue for the rest of it. But as a lawyer, I can tell you there are ways around it. All right, good question, and it's a good policy to always have to write something like you just described. Another one? I only have one more slide, so we can definitely wrap this soon if there are no other questions.
Nope, not at the moment.
All right, moving on. So the bottom line, I'm going to wrap this up, and this is ways to improve your return on investment. And this is kind of a summary of everything we've talked about. You have to be diligent and consistent when you post your 3-day notice as soon as rent is considered late. Don't wait. If you wait until the 15th of the month and then the tenant pays you, you demand your rent, you give a 3-day notice, and they pay you the 20th, you think you're going to get the next month's rent on time? Chances are you won't. They're going to be perpetually behind, and eventually you're going to be the one left holding the bag. You're going to be the one losing all that money. So as soon as a tenant is late, have a policy that you're going to post a 3-day notice, and you do it for all your tenants, and you be consistent. You can choose to sue them or not, or you can wait a few more days if you want, but just serve notices and move on. It's still a judgment call for you if it's been a long-term tenant, the tenant has paid well, and you know for a fact that they lost their job, and now they've gotten a job. It's still a judgment call if you're a landlord or a property manager, but I would not suggest that you wait and listen to stories and allow the tenants to fall behind. All right? The tenants talk to each other, so if you have a duplex or a quadplex and you allow one person to slide, what do you think is going to happen? The other people are going to start sliding too, and they're going to say, well, you let Bob over in 1A pay his at the end of the month. Why can't I do the same? All right? And so before you know it, you have a bunch of delinquencies. The tenant has the option to pay back rent and eviction fees when you file the suit and you get into a stipulation, so you don't lose anything. All right? When you do a stip, you're gonna break even. You're gonna be made whole. So using a stipulation agreement is something you should always think about. As soon as a tenant comes to you after an eviction is filed, you need to always think about that, and it's a good way to save some money. I think that is the end of my presentation here. Do you guys have any questions?
Yeah, one question just popped up, Conrad, was how long can a stipulation agreement last? Like, is there like the expiration date on it, or?
And that's an excellent question. It depends on the judge, but I can tell you this. Most judges, and we practice all over the state of Florida, most judges will not let a stipulation run longer than 6 months. The majority will do 4. They don't want to hold their jurisdiction over the case open for too long. So it will never be like a year, for example, but I would say 4 months to 6 months, you can get away with splitting a payment over that time frame to keep it within the judge's jurisdiction. Anything longer than that, the judge might not sign off on it. Next.
No, great. That's kind of the last question we had there, and we're kind of up on our time. I want to thank you very much for coming on, and for everyone who's listening, Conrad's contact information is here on this slide. I know we'll be talking with Conrad more and possibly have you come on and address some other issues related to owning real estate, especially for people who are, this is their investment. This could be their livelihood or their retirement plan. So we look forward to having you on again in a different capacity, maybe just talking about a different issue.
Absolutely, and if you go to our website, you will also find we did a series of videos covering the same topic. So if you wanted to find out about 3-day notices, you can find, it's on YouTube also. You can watch a video of us telling you how to serve 3-day notices or 7-day notices and so on. We also have a forms resource site, so you can download the 3-day notices that I just talked about, and you can contact me anytime. Anyone, you can get my contact information, and you can email me, and I'll be happy to help you and answer any of your questions. All right?
All right, good. Conrad, thank you again. And again, anyone who's listening, we have a webinar coming up next Thursday, November 10th at noon on how to buy real estate in an IRA. So actually how to get the property in the IRA so that you didn't need to worry about what you're doing with your tenants and serving 3-day notices, etc. So please join us for that. You can always visit our website at advanceira.com for more information. Go to our YouTube page for a lot of other recorded webinars on topics, again, related to self-direction in general, but we have had other guests in the past, and we'll have more guests in the future talking about a lot of other issues as well. So thank you, everybody, for listening live, and thank you for listening to those who recorded, and thank you again, Conrad, for joining us.
Thank you.